Hello everybody and welcome to today's video. Today we will be dealing with an important ethical issue currently in the news. This is an issue that deals with women's right to reproductive autonomy versus right of an unborn child. Recently, the Supreme Court faced an ethical dilemma while hearing a court case. A woman had requested to end her 26-week pregnancy. She said that she already had two other children, that her family income was insufficient to support another child, and that she was under medication for postpartum depression after the birth of a second child. A two judge bench had allowed the termination of the pregnancy, stating that an unwanted pregnancy due to the failure of a contraceptive is the same as a forced pregnancy. However, AIMS Delhi later wrote to the Supreme Court seeking directions on whether feticide can be done before termination, as the fetus is currently viable, that is, it is showing signs of life, and if born, will likely to be a healthy baby. The Medical Termination of Pregnancy Act allows termination of pregnancy in three stages. Number one, termination of pregnancy up to 20 weeks is allowed on the advice of one doctor. Number two, if the pregnancy is up to 20 to 24 weeks, abortion is determined by registered medical practitioners as an exception under certain categories, such as statutory rape, women with disabilities, change in partner support or financial conditions, etc. Number three, after 24 weeks, a medical board must be set up in approved facilities which may allow or deny termination of pregnancy only if there is a substantial fetal abnormality. Earlier, MTP Act 1971 allowed termination up to 20 weeks, but after 2021 amendment, the time period has been increased to 24 weeks. तो बात ऐसा है दैट जनरली अबॉर्शन किया जा सकता है विद इन 20 to 24 weeks, especially where the child to be born has physical or mental disabilities. However, if a woman is 26 weeks or more long pregnant and the unborn child is showing signs of life, then there is a dilemma. If the doctors go ahead with the abortion in this case, it would amount to feticide, that is, killing of the fetus. Rajasthan High Court, in a 2005 case, Kishore Sharma versus Union of India, dealt with the challenging of constitutional validity of MTP Act on grounds that it violated the rights of an unborn child. In this current case, the Chief Justice of India observed that it was a question of reproductive autonomy of women versus rights of the unborn child. Generally, in these cases, the right of women is upheld as more important. He remarked that India does not suffer from a Roe versus Wade situation. Roe versus Wade was the landmark case in 1973 in which the United States Supreme Court upheld abortion as a constitutional right and allowed abortion up to the point of fetal viability, which is the time after which a fetus can survive outside the womb. However, recently the US Supreme Court overturned its decision, thereby criminalizing abortion. The Chief Justice of India remarked that our MTP Act and pro-choice narrative, although allows women to terminate after 20 weeks, the ultimate decision-making power shifts to doctors and doesn't remain with the women, as the doctors can decide whether to abort depending upon fetal viability. The test of fetal viability as a benchmark to allow abortion is a novel idea in India. However, the court as of now doesn't want the woman to terminate the pregnancy, as the fetus is showing signs of life. If terminated, it would amount to feticide. The court, as an alternative, wants the woman to give birth and then put it up for adoption. All the expenses would be borne by the state. However, the woman does not want to go through the pregnancy at all due to her health issues. The Supreme Court itself remarked that forcing a woman to continue pregnancy, endangering her health, is violative of Article 21, that is right to life and liberty, and Article 15, Clause 3, that is state is allowed to make any special provisions for women and children. Section 416 of CRPC provides postponement of death sentence awarded to pregnant women. There's one thing we need to understand from this. There is a huge issue of legislation making from a male gaze. इसका मतलब ये है that in parliament, majority of our lawmakers are men. Historically, women haven't exceeded 14 to 16% mark in Lok Sabha. Therefore, most laws related to women have a patronizing tone that seeks to address female-related problems from a male perspective. इसमें प्रॉब्लम ये हो सकता है that male understanding of such female issues might not lead to the best solutions. For female centric laws, we definitely need female lawmakers. And that is why the recent 128th Constitutional Amendment Act that provides for 33% reservation for women in parliament is a very welcome move. Only when there are more female lawmakers can laws become truly empathetic to the problems they seek to address. This brings us to the end of our video. We request you to kindly click on the like button, share these videos, and subscribe Exact IAS on YouTube and follow us on Instagram so that we can continue to bring you information packed content that will help you in your preparation for government exams. Thank you for watching this video. I will see you in our next.